Welcome to the California Harassment Prevention Training. This training is intended for both employees and supervisors. Please note that the presentation today and today's materials are not being presented by an attorney. If you need legal advice or have questions that require specific laws, please reach out to your counsel for more information. This presentation will cover what is required in the state of California. For employers with 5 or more employees, the employees are required to take 2 hours of training for California supervisors and 1 hour of training for employee only. This training should be done within 6 months of hire, and it should be reviewed or revisited every 2 years. The training must be interactive. If it's not interactive, it must include a test. At the end of this presentation, your employer will provide a test for you. The focus of this presentation is on compliance, not judgment. I do want to welcome you to ask questions. You can always reach out to us at admin@upskillhrteam.com if you have specific questions that you don't want to speak with, or you can just ask your employer to speak with your HR team. We're going to start by talking about inclusivity, blind spots, what the state definition of sexual harassment is, why it's important to prevent sexual harassment in our workplace, what our policy and procedure is, and then what your responsibilities are when it comes to harassment prevention. Diversity is having a seat at the table. Inclusion is having a voice, and belonging is having that voice be heard. You may be wondering why we're talking about this when the topic of the conversation is about harassment prevention. But being inclusive and diverse is like making a bouquet, or cooking a recipe. We take the many different ingredients or flowers to create something brand new and beautiful, or if we're cooking, delicious. The end result wouldn't be the same if all the parts weren't present. There's beauty in including everyone and accepting that our differences are what bring in new ideas, new perspective, and make companies stronger. We all have differences in racial, ethnic, cultural, gender, and religious, etc. backgrounds. We have different geographic and socioeconomic backgrounds and personal values. We're not just categories of people. We each have our own unique recipe of life experiences, and that is what shapes us, and it's what makes our workplaces exciting to share different perspectives. But we must be open to hearing and considering those different perspectives. Now, when I use the word blind spots, what I mean is, areas that we don't think that we're not seeing, but we're just not seeing them because they're not part of our normal experience. So due to our social and cultural experiences, etc., for example, where we grew up, the neighborhood we lived, our parents, our religious backgrounds, we have an innate response. So what this means is our brain makes specific and split-second judgments when we meet somebody about their competence, their friendliness, and their honesty. People prefer people who look like us and share similar experiences because it's comfortable, it's familiar to us, which is not always a good thing because sometimes it leads us into blind spots, and it can really impede making decisions, especially when it comes to those decisions that have to be made in the workplace. We all have blind spots. Everybody comes to work with a variety of experiences, cultural, generational, family origin, religious, etc. Remember, blind spots are just that. We don't often recognize them, and we need to make it a point to be aware of how our actions may make other people feel. If we make a mistake, the best course of action is when we become aware of it, we take responsibility and do better. If we are all open to learning more about our blind spots, it makes a more inclusive environment for everyone. Some examples of blind spots would be always asking a female employee to take notes during a meeting, excluding a coworker who is gay from a sports discussion, assuming an older coworker isn't able to use or learn to use technology, assuming someone is not intelligent because of their accent. These are all blind spots, and they can lead to harassment or bullying, which we want to avoid. It's important to stay open to other people's perspective, and again, be aware of our own blind spots. Workplace abusive behavior is what we're going to talk about next. And again, this all feeds into how we can easily walk into a harassment claim and not even know it. And so it's important to be aware of all these little parts that can feed into, again, something that we didn't even intend to do, but it happened and now we're sitting in an investigation meeting. So workplace abusive behavior refers to the actions or conduct that is harmful, offensive, or degrading toward an individual or a group of employees in the workplace. It's important to recognize the difference between workplace conflict and abusive behavior. Understand where conflict comes from and focus on building a foundation of respect and inclusion. Sometimes conflict can be good. Constructive conflict can be a platform to find creative solutions and broaden perspectives, whereas abusive behavior, it shuts everybody down. It doesn't create psychological safety, and it's the ultimate I win, you lose way to approach the difference of opinion. Workplace abusive behavior involves the misuse of power, authority, or influence to mistreat others. It can often lead to a hostile or toxic work environment. While it is not illegal to be a jerk at work, we do need to remain conscious of how we're showing up in our workplace. Let's talk a little bit more about what bullying is so that we can avoid it. Bullying in the workplace refers to employee conduct that is repeated, intentional, mistreatment or harassment of one or more people. This behavior involves the abuse of power, authority, or influence to undermine, intimidate, or demean another person in the workplace. Bullying, unlike conflict, is never productive. It stifles creativity and growth. It erodes trust in any organization. Bullying can take place in various forms such as verbal abuse, physical intimidation, social isolation or exclusion, undermining or sabotaging work, cyberbullying, and or personal attacks. Bullying should never be tolerated, and we do not tolerate that here. Some of the behaviors of a bully, they tend to blame others, they have unreasonable expectations, they criticize others in shared places, inconsistent treatment, uncontrolled anger, they take credit for others' success, they tend to gossip and spread rumors, they refuse to accept reality, and they often live in the past or the future. Let's now talk for a moment about unlawful harassment. Unlawful harassment occurs when the bully targets someone because of their protected classification. For example, based on their race, sex, pregnancy, gender, religion, etc. One of the protected classifications becomes involved. Once one of the protected classification becomes involved, the bullying becomes illegal. However, it's not unlawful to be a bad leader unless someone has violated one of the protected classes. We're going to be looking at those in a moment in more detail. But unlawful harassment in the state of California is abusive conduct, and a protected classification is what equals unlawful harassment. As we mentioned, when abusive conduct is targeted at someone based on a protected classification, that is harassment. There are 4 legal components. Conduct must be unwelcomed, severe or pervasive, offensive, to the person who is the intended target and involve a protected classification. Again, harassment is the result of personal dislikes, personality differences, or official politics is not unlawful. It has to be based on a protected classification. Now, let's go ahead and start looking at what some of these protected classifications include. Federally, across the entire United States, would be race, color, sex, orientation and gender ID, religion, national origin, disability, age, 40 or over, and pregnancy. These are the 8 protected classes. The federal government has updated this in 2024 for the first time in decades to also include sexual orientation or gender identity, reproductive health decisions, lactation, and harassment from being a remote versus a hybrid employee. Many of these protected classes are a result of laws that have been enacted with the purpose of correcting and discouraging discrimination in the workplace. These are also protected classes for the purpose of harassment. Out of Title 8 of the Civil Rights Act in 1964 came protections for these classes: race, color, national origin, religion, and sex or gender. The next 3 classes were established based on other laws. Out of the Americans with Disability Act or the ADA Act came protections for individuals with disabilities, both physical and mental. Out of Age Discrimination in Employment Act or the ADEA came protections for individuals age 40 and over. Employers cannot use age as a consideration for employment decisions. An employer's job posting cannot contain any language indicating preferences, limitation, or specifications based on age. Age discrimination can come from other employees who are also 40 or over. In other words, the action doesn't need to come from a younger person. Out of the Pregnancy Disability Act came protections for individuals who are pregnant. Some examples of discrimination based on pregnancy include refusing to provide continued coverage under group health insurance for an eligible employee who takes pregnancy leave, or refusing to grant pregnancy disability, PDL, to an employee disabled by pregnancy. As we'll discuss in the next section, these federally protected classes also cover California, but California extends these protections to many more classes for employees, as we'll see shortly. As you can see, California covers the same categories as the federal government, but then also expands those protections for other groups. So again, California adds ancestry, genetics, prohibits genetic discrimination in health insurance and employment, marital status, military veteran status, perceived status. Perceived status is the class that you perceive someone to fall into. Association based on status. These two, as you can see, the orange and the purple, perceived status and association based on status could be that you think that someone is married to a veteran, or you think that you know what someone's class is and you make a decision based on what you think they are versus actually having a conversation. Either way, it's not a good thing, and I would do my best to avoid it. California extends the protected classes even further for national origin, to specifically birthplace, ethnicity, culture, and language, race, including hair texture and protective hairstyles that are closely associated with race, reproductive health decision-making, gender identity, a person's internal understanding of their gender, and then gender expression, the person's appearance or behavior outside. These are all protected classes in California. As you can see, pretty much everybody falls into at least one protected class if you are an employee working in the state of California. So what is sexual harassment? The definition of sexual harassment is unwelcome sexual advances, requests for sexual favors, other verbal, written, electronic, or physical conduct of a sexual nature that affects an individual's employment, unreasonably interferes with his or her work performance, or creates an intimidating, hostile, or offensive work environment. The two forms of sexual harassment are quo prid quo, which is this for this or that, something for something. If you do this, I'll do that, or hostile work environment. So quid pro quo is tangible employment action against the victim. It involves monetary loss or change of the job. An example is Yvette receives a smaller performance-based pay increase than other employees with similar performance because she refused to go on a date with her supervisor, Marcus. So essentially, it's when an employee is somehow penalized or disciplined for not doing what someone in power asks them to do. Hostile work environment is speech or conduct that is severe and or pervasive enough to create an abusive or hostile work environment. An example is Max is leering at and intentionally brushing against Vanessa. So a hostile work environment is not when you get written up for coming into work late and everybody else got written up for coming into late. Hostile work environment is essentially, someone is talking to you or they're doing something that maybe you ask them to stop doing, but they continuously, and the intent is intentional, that they continue to do it. So in addition to speech or conduct, hostile work environment covers explicit or suggestive items that are emailed, texted, electronically provided or displayed in the workplace that interfere with the job performance or that create an abusive or hostile work environment. An example of this is Maria sends a text and instant messages her coworkers with a sexually explicit jokes and pictures. This creates a hostile work environment. It's not okay to keep staring at an employee that, asked you to stop, that shared that they were uncomfortable with it. It's never okay to send sexually explicit jokes or, jokes that may be interfering with someone that is in a protected class at work. It's just not a good idea to do that because we don't ever know how someone's going to receive that information, and it could be some sort of harassment. So I would advise not to do that. So who can commit sexual harassment? Employees at all levels, customers or vendors, members of the same sex or opposite sex, so essentially anybody. And who can be a victim of sexual harassment? Individual or individuals targeted by these statements or actions, bystanders or witnesses not directly targeted. So even if you are, standing around and laughing about, some joke that is off color and someone witnesses it, they can be a bystander of sexual harassment. Why is it important to prevent sexual harassment in our workplace? Sexual harassment harms us all. The most important part of our corporate values is to ensure that all employees are treated with respect and dignity. Engaging in or condoning or not reporting sexual harassment is a direct conflict with our values, and it is also, it is also something that we want to be in compliance with, Title VII of the Civil Rights Act, which prohibits sex discrimination, including sexual orientation and gender identity or expression. We want to remain in compliance with similar state civil rights and fair employment laws. So it's really important to stop this if it's happening, because it really can create distrust in a workplace. It can erode the culture, and it can really create an uncomfortable workplace for many employees. Our policy on sexual harassment is that we have zero tolerance for any unwanted behavior, harassment of any kind. If it's witnessed or experienced, it must be reported to your immediate supervisor and or human resources. We take it very seriously, and we want to do our best to create a safe work environment for all team members. We want everybody to feel safe when they come to work. We don't want any employees to come to work in fear that they're going to be harassed or intimidated or bullied in any way. So supervisor requirements and limited confidentiality. Once a supervisor becomes aware of harassment or discrimination, they have an obligation to act. It is their responsibility. So if they witness it, if they suspect it, or if they hear about it, they do have to do something about it. You cannot just vent to your supervisor or have a off-the-record conversation with them. They are required by law to escalate the issue. Please note that when there is a sexual harassment claim of any sort, the company cannot maintain strict confidentiality. However, they will only share information on a need-to-know basis, meaning they're only going to share information with the people that need to know. This is something that should not be discussed openly. If there is, if you've been part of a harassment incident, it's really important that you just talk to your supervisor and not your coworkers about this, because we need to give everybody a fair chance to investigate the matter, and we don't want to harm anyone else's reputation, and we do want to make sure that the person that experienced the incident is also safe. After you inform your supervisor of the complaint, human resources or management, they will investigate the allegations. Sometimes it's handled internally. Sometimes there will be an outside source that helps with the investigation. During the investigation, all parties and witnesses will likely be called to share their statements. The company and or leadership will review the findings of the report and take necessary actions to correct the issue. The company is obligated to ensure that anybody that participates or reports a sexual harassment claim is not subject to any retaliation. It means that if you have something to share, you can do it without fear of losing your job or being disciplined for sharing the information. So let's talk about protections in California from retaliation. In California, there are several protections in place to keep employees safe from retaliation. Retaliation occurs when an employer takes adverse action against an employee for engaging in legally protected activities or asserting their rights. Here are some key protections that each employee in California receives. Whistleblower protections. Employees are protected even if they have reasonable suspicion of wrongdoing, as long as the reports are made in good faith. So what that means is if you report something and it turned out that it wasn't true, as long as you made it in good faith, you are protected. Reporting unlawful conduct such as discrimination, harassment, violations of health and safety, protected time off, jury duty, military service, voting, bereavement, and meetings with a union. Complaint and proceedings. Employees who file complaints, participate in investigations, or cooperate in legal proceedings against their employee are protected. Family and medical leave for a serious health condition or to care for a family member with a serious health condition. All of these things are protected in California. California law provides extensive protection for those who report harassment, discrimination, etc. To be protected from retaliation, the employee must have made a reasonable, good faith belief that the conduct he or she reported violated the employer's policy, or the law. It does not matter if the conduct complained about was actually unlawful, as long as the employee reasonably and in good faith believed that it was. Just as supervisory employees who engage in discriminatory or harassing conduct will be disciplined, so will those who engage in unlawful retaliation. Retaliation claims can be some of the difficult challenges an employer faces, because even if the original claim of harassment was unsubstantiated, this could still lead to a retaliation claim. For example, let's say Jane here feels Tom is harassing Betty and reports it to HR. Tom gets upset with Jane because he swears nothing sinister happened, and he moves Jane off of a project to show her what happens when someone complains about him. Then after an HR investigation is completed, HR finds that Tom really did not do anything to Betty, and that Jane took the situation out of context. The problem is that Tom still retaliated against Jane, even though there was no legitimate harassment found. This example is what makes retaliation so tricky and problematic. Just as supervisory employees who engage in discriminatory or harassing conduct will be disciplined, so too will those who engage in unlawful retaliation. One study found that 75% of employees who spoke out against workplace mistreatment faced some sort of retaliation. Other studies found that sexual harassment reporting is often followed by organizational indifference, trivialization of the harassment complaint, hostility, and reprisals against the victim. We want to assure you that the state takes this very seriously, and we want to encourage you to be, if there is an incident of any kind, it's better to share it than to not. We just want you to know that you will be protected, and even if you feel like something, after you reported it, something's felt off to you, it's important for you to report that as well. So can it be considered harassment when I'm off the clock, when I'm not at work at all? So employee interactions during non-work hours, such as at a hotel while traveling or at events that happen after work, can have an impact in the workplace. Locations off-site and off-hour activities can be considered extensions of the work environment. Employees can be the target of sexual harassment through calls, texts, emails, and social media. The employer has an obligation to prevent and properly correct. It's really easy to go out after work to a bar, whatever, have some drinks, and easily, let's just say there's a pregnant worker and, someone touches her belly to say, oh, this baby, we're so excited for you. That can be considered harassment. So harassment can happen anywhere and anytime. It can be at a work conference or out of town for business. It can happen via social media, happy hour, via text. So it is really important, that even if you are friends with people at work, that you take it seriously. And if you're not sure if you can maintain your composure, it's best to not hang out with people after work, or certainly not be under the influence of a substance if you can't control it, because harassment can happen after work, and it's important that you're able to maintain your composure, whatever that looks like for you, to make good decisions. Your responsibility is to know and comply. Know and comply with our policy and procedure. Report incidents that you experience or that you directly witness. Cooperate with investigations and support victims. And sometimes supporting victims can simply mean not talking about it. It can mean, only sharing information, with a supervisor so that rumors don't spread. If you hear a rumor, to shut it down, to support the victim, because it's very challenging for anybody. It takes a lot of courage to report any type of harassment or bullying. And, we want to acknowledge that it does take a lot of courage to do that. So in summary, sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal, written, electronic, or physical contact of a sexual nature that affects an individual's employment, unreasonably interferes with his or her work performance, or creates an intimidating, hostile, or offensive work environment. There are two forms of sexual harassment: quid pro quo and hostile work environment. It's important to prevent sexual harassment in our workplace because it harms all of us. It conflicts with our corporate value that employees are treated with respect and dignity. Sexual harassment is illegal under both federal and state laws. Your responsibility regarding prevention of sexual harassment are to know and comply with our policy and procedure, report incidents that you experience or directly witness, cooperate with investigators, and support the victims. That is the end of the employee workplace harassment prevention training. You will now be given a quiz to answer, and then if you are a supervisor, you will have another training to take. Thank you for joining us, and if you do have any questions, please feel free to reach out to your supervisor or the HR department. Thank you for attending today's training.